Do grandparents have visitation rights in Virginia? The answer is no, at least not in the case of a situation where both biological parents are opposed to that visitation and they are fit parents. The United States Supreme Court has recognized that parents have constitutional rights with respect to their children. And the landmark case in this regard is Troxell versus Granville, which concerned a case that came out of Washington State, where the state had passed a statute allowing almost anybody to request custody or visitation of a child. And the Supreme Court struck that statute down and held that it was unconstitutional because, as it was written, it infringed upon the parents' 14th Amendment due process constitutional right to raise their children. That the state in this case was unconstitutionally interfering with that right. Now, the Virginia Code sections that deal with custody and visitation of a child have, in a sense, recognized those due process rights along with the case law interpreting our statutes. And first of all, in Virginia Code section 20-124.2b, the court is instructed in making a custody or visitation determination to respect the primacy of the parent-child relationship in making any decision. The biological parents of a child are presumed to be fit custodians for their children. However, Virginia Code section 20-124.1, which defines the term person with a legitimate interest, a person who can bring a custody or visitation petition or intervene in a suit where custody and visitation are an issue. That definition is very broad, and it can include blood relatives, grandparents, step-parents, former step-parents, people who stood in a role of approximating a parent over the child. So Virginia allows a fairly big category of people who have had some kind of relationship with the child to bring a custody or visitation case, which would include grandparents. The problem is for grandparents that there's a two-part step when both biological parents are opposed to such visitation, or both biological parents are opposed to such a requested change in custody. There's a two-part step in Virginia. First of all, the third party who's seeking visitation or custody or a change in visitation or custody must prove that actual harm would result to the health of the child as a result of the denial of the requested custody or visitation. And as a practical matter, this is very difficult because in the typical case, when both biological parents are opposed to grandparent visitation or forced grandparent visitation, they have not been having much contact or visitation with the child, and if the child is doing okay, it's difficult to show that the child's health will be damaged by not granting them visitation. If, however, they do satisfy that first step, the second step is they must prove by a higher standard than the normal standard. The normal standard is a preponderance of the evidence regarding the best interests of the child. A third party has to prove by clear and convincing evidence that the best interests of the child would be served by this requested visitation or change in custody. So as you can see, it's very difficult for grandparents to obtain visitation against the wishes of the two biological parents. You should consult with your Virginia lawyer to determine if you have a chance of obtaining a change in visitation or custody with a child in Virginia.